Welcome, and thank you for joining us today for a Land Services SA webinar on variation of bylaws. This is a pre-recorded session with a live Q&A session at the end of this presentation. We ask you to kindly hold all your questions until the allocated time, where one of our subject matter experts will be able to assist. Land Services SA is committed to providing an excellent customer experience. One way we continue to deliver value to the industry is through our industry education program, where we produce a range of helpful educational materials, hold regular webinars, and host industry events. Our industry education program addresses key topics or frequently asked questions to ensure you remain up to date with contemporary practices. We want to help set you up for success and believe helping with industry education will help reduce the volume of requisitions, meaning a quicker and more seamless experience for your clients. Land Services SA's subject matter experts assist in delivering our industry education program, utilising their years of experience and respected place in the industry. This webinar was prepared by Jamie Heinrich. Jamie is one of our property examiners. She has over 20 years of experience in numerous positions within Land Services SA. In this session, we will be giving an overview of the variation of bylaws dealing. We have included an example and some key points to remember. We hope this will help you in preparing the LF2 document that is required when you are varying the existing bylaws of a community scheme. Bylaws are a compulsory document for all new community schemes. So why are bylaws varied? There are various circumstances in which the existing bylaws of a community scheme may be varied. The first is when amending a community plan with a Form AP3 or AP5, and the amendment results in an inaccuracy in the existing bylaws. An example would be when the community scheme is being amended from a 2-lot scheme to a 4-lot scheme, and therefore the exemptions under Section 35(1) of the Community Titles Act no longer apply. Secondly, when amending a community plan that has been converted from a strata plan. On filing of a lodgement of resolution dealing, the articles of the strata continue as the bylaws of the community scheme. Therefore, when amending the community plan for the first time, the bylaws are to be lodged as a variation on a Form LF2. Examples of differences under the Community Titles Act that may wish to be amended include setting out the penalties for breaching the bylaws, as these do not apply under the Schedule 3 of the Strata Titles Act, to allow the keeping of animals, or for the assignment of insurance responsibilities to the community corporation. Finally, while the first two scenarios include an amendment to the community plan, the bylaws can also be varied in isolation when a change to the bylaws is requested by the community corporation or pursuant to a court order which does not require an amendment to the plan. This could be to amend existing rules or introduce new rules. Please note that the amended bylaws become active at the point of filing only. The prior bylaws are then superseded and are no longer shown on the title. There are various requirements that must be met prior to the lodgement of the variation. An application to vary the bylaws by a special resolution is made pursuant to Section 39 of the Community Titles Act and must be passed at a duly convened meeting. Please note, there are circumstances where a variation must be made pursuant to a unanimous resolution. For a list of these circumstances and the requirements for a duly convened meeting, please refer to the information published by the Legal Services Commission on their website. An amendment to the bylaws can also be made pursuant to an order of court, whereby the court order must be attached and lodged with the dealing. The LF2 dealing must be lodged with the Registrar General at Land Services SA within 14 days of the resolution being passed at a properly convened meeting of the Corporation. Any changes made to the existing bylaws must not be inconsistent with any prior lodged dealings. The following 4 items must be provided with the form at lodgement: a completed LF2 document with the Form 5 certification in accordance with the Community Titles Regulations, a complete copy of the new bylaws as varied with the Form 10 certification and Form 5 certification, a copy of the minutes of the meeting with a Form 5 certification or the court order, and the applicable registration fees. I will now discuss the first 3 of these further. Here is an example of an LF2 form. Please note that in the case where a strata plan has been converted to a community plan, the instrument affected panel may be left blank if this is the first time the bylaws are being amended under the Community Titles Act. If there are bylaws in existence, they will be shown on the current CT and therefore should be shown in this panel. Here is an example of the first page of the amended bylaws, with both the Form 10 and Form 5 certifications. This version must be the complete set of bylaws as per the original bylaws, with only the changes made by vote at the meeting. Invalid or superseded bylaws cannot simply be struck through on a copy of the original bylaws. The original Form 10 certification that no longer applies should be removed. The Form 5 certification is to be made by the officer of the corporation that is making the application and is certifying that they personally have validated the entirety of the new bylaws are correct and in accordance with the changes voted on. The new bylaws must be prepared in accordance with the Registrar General's requirements, including headings and a comprehensive index, and include the mandatory matters set out in Section 34(2) of the Community Titles Act 1996. Except where a court order applies, the minutes of the meeting held by the Community Corporation to vote on the changes to the bylaws must be attached to the dealing. At a minimum, the following 3 requirements must be met. The first is the Form 5 certification as per the Community Titles Regulations 2011, which must be shown on the copy of the minutes. The meeting minutes must also provide evidence that a duly convened meeting has taken place and a quorum was present. This should be more than just a statement and may be provided by describing the attendees and non-financial members. The results of the vote should be included either by a statement that the vote was unanimous or by listing the number of votes for and against. The changes that were voted on at this meeting must also be made clear, as only those changes can be made. This can be done in 2 different ways. The first is by describing the entirety of the changes within the minutes where they are minor in nature. The other option is by attaching the version of the amended bylaws that were cited at the meeting as an appendix to the minutes. Any changes that were not voted on at the meeting cannot be made and must be reverted, or a new meeting must be held and the dealing temporarily withdrawn. Although the header shown on the bylaws states that the terms of the instrument are not checked by Land Services SA, there are some legislative requirements that we ensure have been met. However, please note that while we will check the requirements listed here and may send a requisition on them, ultimately Land Services SA is not responsible for any inaccuracies. I hope this webinar has provided some assistance when preparing the form to vary the bylaws of a community scheme. For future reference, here is a summary of some of the key points to remember. The changes made to the bylaws must not be inconsistent with any other prior lodged dealings, or they will also need to be amended. The dealing must be lodged within 14 days of the resolution being passed, or it will need to be temporarily withdrawn and re-lodged within 14 days of a new meeting. Ensure all required certifications are shown correctly. The new bylaws must be complete in accordance with the Registrar General's requirements and as per the changes voted upon only. The meeting minutes must contain the required evidence to satisfy Land Services SA that the meeting was conducted in accordance with the legislation. The changes that were agreed to in the meeting must be clear as part of the minutes. Land Services SA's website has a range of educational and support materials to assist you in your day-to-day work. Our Industry Education Hub is a good place to start. This can be found by clicking Industry Education Hub on the home page of LSSA's website. A copy of today's webinar will be published on the Industry Education Hub, together with recordings of previously held webinars. That concludes the recorded webinar section. Thank you for listening. Please remain online for the live Q&A session with our subject matter expert.